Extortion by letter involves sending a written communication with the intent to unlawfully obtain money, property, or something of value from another person through threats. In California, this crime is governed by Penal Code Section 523, which addresses written threats made with extortionate intent. A quick guide to the elements of this offense is outlined in the California Criminal Jury Instructions, CalCrim 1831. A classic example of a claim of extortion by letter is the Oksana Grigorieva versus Mel Gibson case that resulted in the conviction of Mel Gibson for battery. I represented Oksana Grigorieva in the lawsuit against Mel Gibson and in the criminal case being developed against her as well. During that case, Oksana Grigorieva's lawyers made monetary demands for settlement, and some of these were in writing. Law enforcement investigated this, and statements by Oksana as extortion. This extortion by letter investigation and attempt to have Oksana arrested was ultimately rejected by the district attorney of Los Angeles. When Oksana Grigorieva and Mel Gibson battled over custody of their daughter, she also saved the recordings of Mel Gibson making various threats against her. Law enforcement supported Mel Gibson and investigated Oksana for threatening to release those recordings unless he paid her millions of dollars. The defense was twofold. First, that she was not extorting him, but instead there was a civil lawsuit arising out of those threats and his physical assault against her. She contended that he wanted to stop release of the tapes, and he initiated negotiation on that point. The other defense was simple. This was not extortion because she never threatened release of the recordings unless she got money. It just didn't happen. To convict someone of extortion by letter, the prosecution must prove the following elements beyond a reasonable doubt. First, that the defendant sent or delivered a letter or written communication. This means that the accused must have sent, delivered, or caused the delivery of a written message, such as a letter, email, or other form of written communication. There is a body of law that protects settlement demands by lawyers, but in Oksana's case, the investigation did consider whether letters sent by her lawyers were extortion. Just to be clear, the lawyers acted with complete integrity, and the investigation was totally without any factual basis. The defendant must have intended to obtain money, property, or something else of value from another person. In Oksana's case, this was money, but remember, she had been threatened and she had been hit. This gave her the right to sue. There is a requirement that the demand be made by use of threats. A threatening letter or communication must contain a threat to do one or more of the following things: unlawfully injure the victim or another person, damage or destroy property, accuse the victim or a family member of a crime, expose or impute a disgraceful act, deformity, or disgrace to the victim or their family, expose a secret affecting the victim or their family. It can't be an idle threat. The threat must be made with the genuine intent to induce fear. The defendant must have intended to induce fear in the victim, compelling them to consent to giving up money or property. The fear does not need to be immediate, but it must be a motivating factor in the victim's compliance. What shot down any potential prosecution of Oksana is the requirement that there must bear a lack of lawful claim. In other words, the defendant must not have had a lawful claim to the money or property demanded. For example, demanding payment for a legitimate debt through threats still constitutes extortion if the method used is unlawful. This lack of lawful claim was the ultimate failure of the attempt to have Oksana Grigorieva arrested. Her claim was legitimate and she was entitled to compensation. Defeating the potential charges was important because extortion by letter is a felony in California. The crime can be punished by up to 4 years in state prison. There are also fines of up to $10,000. A conviction of this type of felony could have had huge impacts on the ongoing child custody dispute as well.
Daniel Horowitz is a criminal defense specialist certified by the State Bar of California Board of Legal Specialization. Daniel has been a law professor, television legal commentator, and he is a veteran trial lawyer. You can reach Daniel at 925-283-1863. Thank you for watching our video.